Quiet, please. No need to shout. No need to yell. No need to have a riot. Shut your eyes. Take a deep breath. Oh, you've gone all quiet.
What?
Thank you for being here today. I'm Janlyn Obrial from BS Criminology 2C. I'm here today to talk about what rule assigned for me. Let's start. First of all, we proceed to Rule 13. What is Rule 13? It's talk about arrest. Arrest is taking of a person in custody in order that he may bound to answer for the commission of an offense. All arrests shall be made on only basis of valid warrant of arrest issued by competent authority except in instance where the law allowed warrantless arrest. No violence or unnecessary force shall be used in making an arrest. As a general rule, arrest can be made on any day of the week and at any time, the day or night. Only judge are authorized to issue warrant of arrest. A warrant of arrest is no longer needed if the accused is already under detention and order committed and used to charge of the warrant of arrest. Then we have the following are immune from arrest. The first is a senator, a member of the House of the Representative while the Congress in session. The second is the diplomatic agent under the Vienna Convention on Diplomatic Relations. Warrant of arrest. The warrant of arrest is the written authority of the arresting officer with making an arrest, meaning to say the arrest is made with the warrant of arrest is lawful. The warrant be implemented within 10 days from receipt after the expiration of such a period. The police officer assigned from implementation shall make a report to the judge who issued the warrant. In case of his failure to implement the same, shall state the reason, and the judge shall issue the alias warrant to all police stations to alert them. Then we proceed. Arrest without a warrant. Arrest without a warrant. A peace officer or private person may without a warrant arrest a person. With the presence the person to be arrested had committing, or is the attempted to commit an offense. He has the personal knowledge of fact or circumstance that person to be arrested has committed. With the person to be arrested in a prisoner who has escaped from a prison of penal establishment. This is a right of arresting officer. Police officer may summon assistant. Right of a police officer to break into the building or establishment. Right to break out from the building or establishment. Arrest after escape or rescue if a person lawfully arrested escape or is rescued. When a woman or children are among the arrested suspect, the arresting officer shall task the woman and children protection, thus to conduct the pat-down search. Serving of warrant of arrest. Introduce himself and show proper identification. You know how to show your proper identification as a police officer. If a refuse entry, the police officer may break in any resident, office, building, and other structure where the person to be arrested is or reasonable believed to be in after announcing him for use. Secure the person to be arrested and use handcuffs. Conduct a search and the person arrested. Inform the person to be arrested of his right under the law. No unnecessary force shall be used in making arrest. Bring the arrested person to the nearest police station for a documentation. Deliver the arrested person to jail or prison upon the issuance of commitment order of the court.
Stop it. Get some help.
And the next rule is Rule 14. The Rule 14 is the search and seizure. What is the search and seizure? A law enforcement agent examination of a person's home, physical or business to find evidence that crime has been committed. Requisite for the issuance of search warrant. A search warrant shall be issued only upon probable cause in connection with one specific offense. It may be done in daytime only. The following properties may be the object of search warrant. Properties which are the subject of defense, like a stolen object. What is the validity of search warrant? The warrant shall be valid for 10 days from day of issuance and may be served in any day within said period. Thereafter it shall be void. And the time of search, the warrant shall be served during time unless there is provision in the warrant allowing serving at any time of day or night. There is exception if the subject to be searched is bar or any establishment that open at night time only. Then, authority of police officer with conducting search in the conduct of search if the after giving notice of his purpose and authority, the police officer is refused admittance to the place of search, he may break open outer or inner door or window in part of house or anything therein implement the warrant of liberate himself of any person lawfully attending him when unlawfully detained therein. And prohibited act in the conduct of search by virtue of search warrant. House, room, or other premises shall not be searched except in the presence of lawful occupant thereof or any member of his family, or is the absent of letter in the presence of two witnesses. Note: two witnesses rule are applicable only in treason and search and seizure. Then, inventory and delivery of proper signs. The police officer who confiscate proper under the warrant shall issue detailed receipt in property seized to lawful occupant of premises on absence of such occupant shall do in presence of two witnesses. The receipt shall be include items seized under the plain view doctrine. The police officer must deliver and receive in the place in which the found the seized property and duplicate copy thereof. The police officer must forthwith deliver the proper seed to the judge who issued the warrant, together with the inventory thereof. Valid search and seizure without search warrant. Valid search and seizure without warrant. Search made incidental to a valid arrest. A person lawfully arrested may be searched for the dangerous weapon on any which may be used or which may be constitute proof in the commission of the offense without search warrant. Search of moving physical in the police officer conduct the checkpoint and through the plain view doctrine he saw the questionable item inside the car.
Oh God!
And the second to the last is Rule 15. What is the Rule 15? The Rule 15 is investigation by the territorial police unit after armed confrontation. We have a responsibility of the territorial police unit and the scene of the crime operation. This is a SOCA team to process the crime scene and the mandatory examination of firearm seized and confiscated during the police station. I mean police operation. And the last is the inquest proceeding necessary when the suspect die. What is the inquest proceeding necessary when the suspect die? In case of armed confrontation wherein the suspect die, the team leader of the operating unit shall submit the incident for inquest before the duty. The inquest prosecutor priority the removal of the body from the scene except the area where there are no inquest prosecutor, in which case the territorial police unit can proceed with the investigation.
No, God! No, God, please, no! 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 No!
And the last rule is Rule 16. The Rule 16 is talk about judicial affidavit rules. This rule shall apply to all action proceeding and incident requiring the reception of evidence before the court in place of the direct testimony of witness in order to reduce the time needed for complaining their testimony. Application of rule to criminal action. This rule shall apply to all criminal action where the maximum impossible penalty does not exceed 6 years. A judicial affidavit must be prepared in the language the witness is familiar with, accompanied by a translation if not English or Filipino. It shall be include the witness name, age, address, occupation, lawyer, statement of truthfulness, question and answer, highlighting the circumstance of the test, relevant fact, and attached evidence. The affidavit shall also include the witness signature and date of examination. The judicial affidavit must be included sworn attention from the lawyer who conducted the witness examination, standing they accurately recorded the question and respond and did not coach the witness.